Good morning. Good morning. Just to make sure you're in the right church or pew, this is civil jury trial. That's what we're going to be talking about. Now, I'll tell you what I told the panelists so that you know what's going to happen. I told them we're going to have a dialogue. There are no prepared speeches. I've told them that they are free to speak anytime they wish to speak, and I've urged them to speak as often as possible so that I don't have to work very hard. In effect, we're going to have a bull session. We're going to have a bull session about civil jury trials. We're going to do that, I guess, until 12:45, our masters tell us. And at 12:45, you are free to come meet them. Have an informal chat with them, ask them anything you wish to ask them, seek a clerkship, I don't know. Why don't each of you introduce yourself? They do have biographical information. Brian, why are you here, other than that you were invited? What do you bring to this table?
Well, I think what I bring to the table is that I was a legal services lawyer in Arkansas for 5 years at the beginning of my career in the 1980s. I was in court 3 days a week, had a couple civil jury trials. They're much harder to get now. And so I'm vitally interested in this topic. I'm also very interested in a related topic, which is the increased use of summary judgment and the effort to take the case away from the jury early on in the case. And that concerns me quite a bit.
Hey, Victor, why are you here? What do you bring to this table, other than good looks?
Well, I was in court once with my divorce. I've done plaintiff's work for 14 years, defense work for about 20. I write the Prosser, Wade & Schwartz case book, and I've always been interested in the American jury and how it works, and have great respect for it, and maybe have an observation or two.
Good. Judge?
I'm Sarah Vance. I'm the Chief Judge in the Federal District Court in New Orleans, and I am a trial judge. I enjoy trying cases. When I was a lawyer, I tried cases. I tried civil RICO cases, antitrust cases, criminal RICO cases, failed bank cases before juries, and so it's something that interests me very much, and I'm happy to be here.
Brad?
My name's Brad Friedman. I'm a partner at the Milberg Law Firm. We do primarily plaintiffs' work, and I guess I'm here because one of the best experiences I ever had in the law was a 6-week-long jury trial, which was tried to verdict, and I'm dismayed to realize that that was now nearly 20 years ago.
Judge?
My name is Myron Thompson. I'm a federal district judge in Montgomery, Alabama. I suppose what I bring here is I've been on the bench for almost 30 years. I have seen the concept of jury trials change dramatically from the South, where a jury trial was your greatest nightmare. We did not want the common culture, to today's sort of concept of what a jury trial is.
Mm-hmm. Judge?
I'm Bill Young. I'm a trial judge.
That says it all.
It does for me.
And you're from Boston.
I am.
Judge?
I'm Bob Pratt. I'm the Chief Judge of the Southern District of Iowa. I, like Brian, was a legal services lawyer. I am the only legal services lawyer, however, to have left legal aid and gotten poor clients. What you didn't hear from Judge Young is that he is really the leader nationally among trial judges with respect to this incredibly important issue. So his modesty, I'm not going to let him get away with it, Professor Miller, if that helps.
In the spirit of full disclosure, I know a few of these people. I have an affiliation with the same law firm that Brad is a partner in. I've appeared before Judge Young, been beaten into the ground by him, and he will never forgive me for handling an appeal that reversed him. That's enough for the disclosure. I'm having a terrible time with 4 judges up there. It's very hard to stick to the notion of calling people judge, because then they'll have an identity crisis. Let's start with cause. We all know that the incidence of trial in the federal courts on the civil side is declining. We all know that the incidence of jury trial in those civil cases that are tried also is declining. So, why? The question is why? Judge Young, start.
Well, there are broad reasons, and I want to focus on one specific narrow reason, and on this I'm somewhat of a heretic. Some of the broad reasons are that the jury is a quintessential local institution. Local institutions have gone something into the shade in part because of their failure during the civil rights movement. At the same time, because large economic, and I'm citing jury studies here. This is not a personal view of my own, though I agree with it. Jury studies show that large economic entities are benefited by dispute resolution mechanisms other than a jury. So we can debate those things. But the heretical notion that I want to throw out to you is that the fault, if you're asking us here, and I think it is a fault, that we're losing this stunning, as de Tocqueville now, stunning experiment in direct democracy. The fault is not in the stars, but in ourselves, especially the trial judges, the federal trial judges. We have far too much deconstructed what the job is, and now do not put at the very center of our operation the trial of cases. And when I start off like that, people say, well, you know, he's zany, he doesn't agree with case management. He doesn't agree with that cases should settle. Absolutely wrong. Most cases should settle. Lincoln had the right of it. Litigation's the absolute last resort. Most civil cases should settle. And anyone who's appeared before me knows that I believe in management. But management to a goal. And the goal is, if you're not going to settle, and we leave that to the litigants, then we'll give you a prompt and fair trial, jury or non-jury. That's your choice. And that's the very center of what we do. The support people can handle the peripheral things. We trial judges are the ones who best, and we should, understand that our core function is the keeping alive and making flourish the American jury system. And we're failing.
Of course, I largely agree with everything you say, especially as a big advocate of civil jury trials, but I think I'd almost go further and maybe differ with you a little bit, in the sense that my experience, at least, is that increasingly there are so many hurdles, and hurdles we've never had before, to get to a jury trial, that such a trial is a remote possibility. I mean, you have hurdles that you've always had, like motions to dismiss, but increasingly those motions seem to be granted on bases they were never granted on before. The notion that, well, the allegations of the complaint don't seem logical to me as the judge. You never heard of that 20 years ago. And then you've got all these new requirements. You get statutory requirements such as the PSLRA pleading requirements that essentially turn a motion to dismiss into a motion for summary judgment, while at the same time imposing a discovery stay so that you have no access to the facts in order to plead a summary judgment type complaint. And then you've got Daubert motions, which you never had before. which are imposed on us by the Supreme Court, which is, of course, part of our judiciary. You've got Dura motions in securities cases where now you've got to, depending on what court you're in front of, actually prove loss causation or simply allege it, depending upon what court. The Supreme Court says you merely have to allege it, but the Fifth Circuit certainly now says you essentially have to prove loss causation in your motion. You've got in the Second Circuit the IPO decision, which in class actions says essentially you've got to prove the merits of your case as part of your class certification effort. Then you get down to summary judgment motions, where however far the courts have gone on motions to dismiss, they've now feel free to go even further on summary judgment motions and essentially try the case at summary judgment if you're fortunate enough even to get the case to go that far. And so the odds of getting a jury trial are remote.
Now, Judge Vance, I saw you shaking your head on the vertical as Brad was speaking.
I totally agree on the issue of new barriers to jury trials. And in addition to the ones that Brad mentioned, we have issues like standing, immunity doctrines. There have been a whole lot of obstacles placed on rights that were congressionally declared by the courts to create a mechanism to eliminate cases before trial. And you also have risk aversion, where I think in cases where there is a lot of money involved, there is the fear of what's going to happen in a jury trial. But one comment I would like to make is that people don't realize that some judges are risk averse too. Once that jury trial starts, you don't know what's going to happen. And you could screw up in public. You could get reversed. You have to deal with post-trial motions. And so I think that in the calculus of how judges spend their time, there is for some judges an element of risk aversion too in trying a case to a jury and maybe getting it wrong. And there are more reversals of fully tried cases than there are of cases that go up on summary judgment.
And now you're going to blame law schools for lousy procedure and evidence courses, huh? Now, Brian, you mentioned summary judgment when you introduced yourself.
Well, I mean, let me just add to the list. There's no question standing and immunity. We see cases where the other side, paradoxically claims that the case is both not ripe and it's moot. All sorts of immunity doctrines. And the judge did not mention, of course, in many cases, the inevitable motions regarding arbitration and preemption. And many of what I want to get at in summary judgment here is that many of those motions actually contain facts which are disputed, but they don't, when they're in those kind of motions, like preemption, they don't get to the jury no matter how hard we argue it. The judge takes them and decides that there's not a dispute of a material fact. We've never gotten one of those past a motion. Sometimes we win them, but we never get the pass.
Well, I suspect you'd say that also happens on summary judgment motions.
That's what I'm saying. Summary judgment. That's what I'm referring to. Yes. And so there's two questions here. One is the question of whether there's facts. The other is questions of whether there's a tougher standard on summary judgment than there used to be. I'm referring here to the former point, that there are actually facts there where the judges perceive these as questions of law.
A basic change that's occurred over the past 10 years, at least from a defense firm, is cost. And we've seen it really go up. A simple product liability case now is about $500,000 to defend. And Schick-Hardy has we have 242 lawyers who've done jury trials, which is a lot. We're not a settling machine. But the cost is very, very high. And on the plaintiff side, they don't want to be spending their time in court. They're not paid by the hour. So there are incentives on both sides now to go to settlement, and a lot of it is money-driven, especially in the past 3 years.
But there's nothing wrong with that. Well, the costs are too high. The costs are too high, and the courts are too slow. But there's nothing wrong with those incentives to get to private resolution. Judge Vance, I'm glad we're being honest here. I mean, she gives you the judge's point of view. My point is a more modest one. My point is that trial judges ought put the trial as the centerpiece, and they ought organize their time so that we're the only Article 3, we're the only people who can summon juries. I mean, if you'll consent, magistrate judges can do it. But other than that, the 674 United States district judges in the federal system, we're the ones who summon juries when the Constitution guarantees a jury trial. Now you've got people here who understand our bias. We think this is a good thing. Trial is not a failure. Most cases should settle, but some should try. And our goal should be, the RAND study confirms this, we ought to cut down on the time between the filing of the complaint and the time we will give you a trial, because that's the greatest cost containment there is. We ought to get to trial. Of course we ought to be open to settlement. We ought to encourage settlement. We ought to know all sorts of things about how to settle, and we ought to suggest them. But the points about summary judgment are well taken. Arthur has the best article that I know, the pretrial rush to judgment in the NYU Law Review. Take a look at his article. It'll tell you about summary judgment.
It's very long, I warn you.
No, but read it all. Now, but as a practical matter, and he teases me about getting me reversed, I haven't forgotten because I remember those things. But look, I grant summary judgment whenever the law requires it. That we're sworn to do that. The interesting thing is, I've never been reversed when I granted summary judgment, and I've been at it, federal court, for 24 years. So I've got the stats there.
I think I'm sorry.
Go ahead, Judge Thompson.
Okay. I'd like to comment on a couple of things here. 30 years ago, you went to trial in 6 months. And the reason you could go to trial in 6 months was because you did your initial discovery. You didn't have all of these issues raised between the date that you filed your case and the date that the judge set it for trial. And as a trial judge today, that is virtually impossible because of all the barriers that you've mentioned. And I want to take issue with just that it being the trial judge's fault. I think, and I know this may even be somewhat more heretical, that there has been a concerted effort to make sure that certain cases don't go to trial.
By who?
By a Supreme Court. Oh. And I think that, for instance, to get a Title VII case to trial today borders on impossible. And the barriers that have been set up by all of the shifting burdens of proof, by all of the immunity issues, by all of just so many different issues. 30 years ago, you would file your lawsuit. You'd say someone discriminated against me because of my sex or race, and you were in trial in 6 months, and you had a decision from a jury or a judge.
Well, let me just say...
Now the barriers are just so tremendous, and it's our own court system.
Yeah, Myra, Judge Thompson's hit on the first victim of the war on drugs is the federal courts, because criminal cases come first, and I think if you talk to anybody who's on the front lines and doing trial judging, dockets, at least in my district, are overwhelmed with drug cases, and they get priority. Until 1991, Title VII cases were not triable to juries. What Judge Thompson has indicated, the 1986 trilogy of summary judgment law that is the subject of Professor Miller's law review article, I think, and I think Professor Miller points this out, changed the landscape. If I can go so far as to say you are almost encouraged now as a matter of what I think Judge Yudin called, quote, trial management. We're now trial managers, not people who try cases. You're almost encouraged to not, quote, waste judicial time. And I don't think it's as black and white as Brad indicates, summary judgment. You know, I think when I'm getting criticized by the defense bar for letting too many, quote, frivolous cases go forward, or I'm getting criticized for the plaintiff's bar for granting too many, I'm probably at the right place. What is frustrating to a trial judge is I tend to let things go if I can, because I think it's much more satisfactory to get a verdict than to get a piece of paper saying plaintiff had no case. But what's frustrating for me as a trial judge, when I let a, quote, skinny case go, about the second witness when the jury is looking at me saying, what am I doing here? That's very frustrating for me. I do post-juror evaluations anonymously. In all the trials that I've had, and I've been on 12 years as of Monday, I've only had a couple of jurors tell me this was a frivolous lawsuit. So it's not all black and white. They aren't all meritorious cases. As Judge Young indicates, sometimes your job is to grant summary judgment. But hopefully, if you have well-prepared lawyers before they file their lawsuit, most cases won't go by way of summary judgment.
I will say there does seem to be a seismic shift in the overall reception that particularly plaintiffs' lawyers, I think, get in courthouses today. It used to be the case that you walked into the court and essentially the message from the bench, and I don't blame entirely judges for this, or even mostly, a lot of this comes from Congress, but the message you got was, look, to both the parties, either you resolve your differences by settlement or go into trial in 6 months, a year, 18 months, whatever it is. And, very often there'd be a settlement, but it was because there was a threat of a jury trial out there. And today, and I almost throw this open as a question, I get the sense that members of the bench are oftentimes looking for a way to get rid of the case, for an excuse to get rid of the case.
With what motivation would you suggest?
Well, I think to avoid I think the judges are overworked, frankly. I think there's not enough judges. There's too much criminal work that really drowns out the civil work. A lot of judges, I think, feel, perhaps quite rightly, that criminal cases are more important than civil cases, and their dockets are just too big.
Judge Vance?
I think that's absolutely true. And one point I wanted to go back to, and it's the issue of the obstacles that parties face in getting to trial, and it's connected with the issue of discovery. I mean, we haven't talked about the expense of discovery, but that's a huge factor in why cases settle. And the Twombly decision, which I think was a disaster, was somewhat, I think, related to the Supreme Court's perception that trial judges won't control discovery. So we're going to take away these give them a way to take away these complicated cases on a motion to dismiss. So now we have a plausibility standard that is used in a motion to dismiss, and I suggest to you that plausibility is often in the eyes of the beholder. This test started out in the Matsushita case, which is an antitrust case, and plausibility in economics at least has some purchase in the discipline of economics. But plausibility in tort, plausibility in employment discrimination, what does that mean? And I think that the Twombly decision, which has been cited no less than 35,000 times, is a huge obstacle, and it's now the roadblock starts even earlier with the motion to dismiss that we now take ever more seriously. It used to be on Rule 12, now we've got to look at it.
Well, if you didn't like Twombly, I'm sure you hate Iqbal,
Yeah.
which
Right.
I think is like an exclamation point
Right.
or a dagger in the heart.
She's got the key part of Twombly, and I simply want to emphasize that I happen to have Justice Souter's words here.
You
How about
travel
this
with it,
person?
Judge?
No, these particular words. He says, well, let's see here. I had these words. It is no answer to say that a claim just shy of a plausible entitlement to relief can, if groundless, be weeded out early in the discovery process through careful case management, given the common lament that the success of judicial supervision in checking discovery abuses has been on the modest side.
How does he know that? How does he know that?
Well, they have a particular advantage on the Supreme Court. They've never practiced law.
Now, okay. There's something. Justice Souter is the only one who ever was a trial judge. Now, he was a trial judge for a couple of years, and he remembers that. And one of the sad things is that his criticism is, in significant measure, true. We should be more aggressive. My point is that we should, and what I try to do is and colleagues, at the initial case management conference, we set the trial. I do a running trial list, but we set the trial month. Everything works off that. And I say to them, you know, the grounds for continuance are very few. If you represent an individual, that individual dies. Or, since I don't give a fixed trial date, if you're on trial anywhere else, the local housing court, I'll wait. When you get done there, you can try before me. And that's what I try to build everything around. We're going to trial. So file all of the stuff that Judge Thompson says, and, you know, if you overwhelm me, and it happens, you will be getting little cards from me, and though I don't say so, the question posed is, what part of the word denied don't you understand?
But, you know, the only thing is about that setting of the trial date, it still doesn't address the issues that our co-panelists have raised. Getting past summary judgment today is a monumental effort. I think that you'd have to be blind not to know that the general reception of certain claims brought by, quote, small people in our judicial system is such that those cases tend to be, how can we get rid of them and how can we get rid of them quickly?
Fairly, I agree.
Not fairly, quickly.
No.
I'm supposed to be a moderator and neutral and not involved. Well, BS to that. Judge Young, I'm going to say a terrible thing to you.
You have before, respectfully.
A fellow member of your bench once said to me, if any case on my docket reaches trial, I have failed. I will go to the grave thinking that was one of the most stunning statements ever made to me by a judge, and to me is a complete negation of everything you believe.
It is, and I rest my case. That's not my co-panelists here, but that is too often the view of those people who call themselves trial judges. Now, maybe we are the products of our experience, and I started out on a state court. And the senior active justice of the court where I first sat as a judge said this is a trial court. Trial judges ought to go out on the bench every day and try cases. And I thought that was the job. And now, 32 years later, I still think it is. I agree with Judge Thompson. Absolutely. He's right in what he says. I'm just swimming against that stream.
I'd like to make one point. There can actually be a value in going to trial itself. And I'd like to give an example. Periodically, I will try prisoner cases, pro se prisoner cases. Obviously, I know before that case goes to trial, the likelihood that that prisoner is going to win borders on zero, because it's usually the prisoner's word that I was beaten against these three guards' words that we didn't beat him. But I think that every so often, a state prison institution should go to trial to let them all know that if you beat a prisoner, you don't get summary judgment, you don't get dismissed, but you have to come explain yourself to 12 jurors. And I think it has a prophylactic effect of discouraging prisoner abuse. And so sometimes I think even though the judge knows the case is going to be lost, our system should have certain cases, especially institutional cases, by those who are weak or who are disenfranchised, to go before 12 people and be called to answer.
I think that's true in products liability cases. There are certain products liability cases ought to be tried. We ought to know this product's dangerous. You know, there ought to be a judgment to that effect. I mean, certain antitrust cases ought to be tried. If people are fixing prices, the market ought to know it. I mean, I think that applies in not every single case, and I agree most cases settle, and they settle because parties want them to settle. Most people want to resolve their disputes by amicably. But I agree with you. I think that, but there are other areas in which society would benefit from public accountability that results from a jury trial, an appeal, which produces precedent. I mean, the law is stymied in its development if we don't get cases up to the courts of appeals to be resolved on a full trial record instead of a truncated summary judgment record or no appeal at all. So, I mean, I definitely agree with Judge Thompson's point.
I think you meant, Judge,
Yeah.
or the product is not defective, right?
Or the product is not defective. Yeah.
Let me add to that with a slight variant on it. The first jury trial I have, I think it was in '86 or '87, was a man who lived outside of Sheridan, Arkansas. His income was family income was about $7,500 a year, and about half of that income was derived from driving a bus for the local school district. And he was fired. He was probably fired because of his religion, actually, but we couldn't prove that. But he had a contract, and so we brought a federal due process claim and pendant state claim. And the contract claim and parts of the due process claim were tried to a jury. Now, if you look just at the case itself, and we got a verdict, and we ended up actually getting some pain and suffering damages because of some credible testimony from his wife. But if you look at the case itself, and this is the point Judge Thompson was making, it was inefficient in itself. If you look at it just economically, right? I mean, to go to everybody had to go to Pine Bluff, where the federal courthouse was, and bring in the jury, and so forth and so on. But one, we were looking over the shoulder of this powerful institution in this town, one of the 2 or 3 most powerful institutions. They weren't going to do this again, which is not give him a hearing before they got rid of him. They probably were going to be careful about their discriminatory motives as well. Second of all, the case had a transformative effect on the jurors, all right? And not because they thought they had an enormous amount of power and that they wanted power, because when you talk to them afterwards, it had an enormous effect on their citizenship, okay? That was, and this is a point made in, I just have to tell you to go read Judge Young's article in the volume 32 of Boston College's International and Comparative Law Review, because it talks about all this in great detail. But the effect of making these folks feel part of the citizenry was enormous.
Yeah, I mean, I'd like to sort of underscore that in a slightly different way, which is, it used to be, and sadly isn't any longer the case, I do securities class actions. We would have defense lawyers come up to us routinely on a sort of confidential basis and say, I have to tell you, thank God you guys are out there, not just because we'd be unemployed without you, but because when I'm advising my clients, you wouldn't believe the hair-raising stuff that they would like to try and get away with. And the only real thing I can say to them to convince these corporate CEOs not to engage in some of this horrible conduct, whether it's product liability conduct or securities violations or what have you, is tell them, if you do that, the Milbergs of the world or whatever are going to be all over you, and they're going to sue you, and you're going to go through misery, and that's a deterrent. And you lose that deterrent when the risk of jury trial goes away. And of course, Judge Pratt, I think, mentioned, the problem of letting the skinny case go to trial. And to me, the issue there is that's all well and good, but who's to decide what is the skinny case? I mean, one judge's skinny case may actually be a meritorious case to jurors. And judges are not, they're terrific people, but they are not a cross-section of the community. They are better educated. They tend to have a very different view of life and are perhaps not the best judges, although they are judges, of what a jury would find to be a meritorious case.
But they're now charged with the obligation under Twombly and Iqbal to determine plausibility. And when I hear the word plausibility, it almost sounds like a reasonable person test. And then I say, gee, that used to be a jury triable question.
Exactly right. I mean, that's really what I'm up here railing against. I think it is completely inappropriate to expect or ask a judge to make that plausibility determination. Oh, they can do it, but they can only do it from their own perspective, from their own experience, from their own background, from their own perspective, and bringing their own biases to the case. which, in the case of the bench at large, are far narrower than what you get in the broad citizenry. Most judges are not like most jurors.
Judge?
Professor Miller, I think that we're approaching this way too narrowly. The interests of lawyers and clients, plaintiffs and defendants are important, but what we really overlooked is the value that serving on a jury, and I think Brian mentioned this, there are actually studies that prove one thing. There's a jury service as an invitation to citizenship, assessing the civic value of institutionalized deliberation. Judge Vance and Judge Thompson both hit on this as well. I think there is value to going to trial on the Skinny case. I guess I separate out skinny from frivolous, and that's probably the reasonable man standard that you're talking about. But when you do get, I gave Judge Young and Judge Thompson, I just finished, one of your colleagues wrote a biography of Hugo Black, and there's something about jury values, citizen participation. They talk about Justice Black growing up. I'm sure Judge Thompson knows Clay County, Alabama, much better than I. But he tells the story about the power of the jury in both civil and criminal cases. The landowner in Clay County was accused of stealing a mule, or a fellow in Clay County was accused of stealing a mule from the richest landowner in the county. So, of course, defense counsel did his or her job and put the landowner on trial. The jury came back with a verdict that says, we, the jury, find the defendant not guilty provided he return the mule. The judge told the jury there is no such verdict known in the law, go back and deliberate. 5 minutes later, the jury came back and said, we, the jury, find the defendant not guilty and he can keep the mule. So I do think that, this is much too narrow to be limited to lawyers and clients and judges. This is about community values and the power of individual citizens in the self-government of their country.
It's about democracy. That's what the jury is. It's a New England town meeting writ large. But it does not serve us, it seems to me, to rail against statutes and, we're trial judges, higher court decisions. Make no doubt about it. We are sworn, unless it's constitutional problems, to carry out what the Congress has said. So we're not the forum to change what Congress has said. If we're talking the securities law, the private litigation, the Securities Law Reform Act, you may not like it. Our job is to apply it just the way Congress wanted it applied. And that, I guess, is why I've maybe it's fallen back to say, what can we change? How can we make our jury system better? And there's lots of efforts. I mean, to let them ask questions, to let them take notes, instructions in English. I'm for all of those things, naturally in English, in plain English. But here are some other suggestions. One, big mistake that the feds went to 6-person juries on the civil side. We ought to go back to 12-person. All the sociological studies say that, and the rule only requires that we sit civil not less than 6. So we can still impanel 12. My colleagues and I routinely do it. We all should, and we judges should be talking it up. We should publish our trial hours. We keep our we keep time records too. We have very good statistics. Do you know the average time that an active, not a senior, an active United States district judge spends on trial nationwide, 2008, fiscal 2008, 189 hours. So that means half of them are less than that, half or more. Now, that doesn't mean we're not working. Judge Vance has it right. We're working as hard as we ever have. What are we working on? All the things Judge Thompson talks about. We're handling all these motions. We're trying to deal with that, to cut our way through to get to trial. Now, I say we should publish that. And why should we publish it? Because we don't even mention it in all our own statistics about throughput and the like. And believe me, we look at this stuff. We're trying to manage a huge system. if you published the time on average we spent on trial, I guarantee you one thing, it would go up.
That's absolutely true, because last year, 2007, the Congress was doing a study on courtroom utilization. And did you look at the trial rate in 2007?
Yeah.
It was like 4%, which is high, because it was 0.9% in 2008. But there were probably about 4 times more trials during the year that we were actively monitoring for Congress how we were using our courtrooms. And the courtroom utilization went way up, and the jury trial rate in 2007 is aberrationally higher than it's been in a long time.
Now, let me drop a footnote on Judge Young's 189-hour statistic. You have to understand the 189 hours includes civil trials, criminal trials, bench trials, jury trials, and trial-like hearings, such as Daubert hearings, and possibly an evidentiary-based class action hearing. So 189, if you thought that's a lot of hours, start cutting that down by the categories I've just listed for you, and you will see that how many hours of the 189 are spent in actual jury trial?
Well, in actual trials, I've only done a study of our own court. It's inflated by about 33%. That'd be jury and jury waived. If you define trial as a proceeding which will result in a verdict or a finding, it's inflated by about 33%.
I'd like to draw a distinction, and I think perhaps in this sense I'm unique here. And the distinction is between jury and non-jury trials. I came to the practice of law, and I came to the position of judging with not a very nice view of jury trials. And I mentioned this to Judge Young. When I was a lawyer, I thought the worst thing that could happen to me in a case was to have a jury trial. And my practice mainly was civil rights work. And I knew that what I did not want was democracy. And what I did not want was community values. So I wanted a judge trial. And of course I wanted a judge trial before certain judges too. That didn't necessarily assure it either. But, you know, when you study juries in that context, even if you go back historically, now, Judge Young, you've done this more than I have. I'm not a historian. But, you know, I know with the development of equity law and so forth, that was in response somewhat to juries.
And hear him. This is absolutely right.
So, you know, we have to just, you can't look at this myopically. You can't look at it within the last 30 years. And you can't look at it purely nationally. To some degree, you have to take in it regionally. And so I have changed my views, perhaps only because I think the society in which I existed as a child is not the society that exists today. And I indeed like a jury trial, and I would love to have a sex discrimination or race discrimination or an age discrimination case tried by a jury. But that wasn't true 15 years ago. In fact, I just want to tell one little anecdote. I called a jury, I was impaneling a jury, and asked the question, if there's anything you'd like to change in society, what would it be? And one juror stood up and said, life tenure for federal judges. So that gives you an idea of the kind of notion and the reception that the federal judiciary had among jurors and how much they essentially disliked what we were doing and the types of cases we were having. So this democracy concept has its limitations.
Right. Was he or she struck for cause?
You know, I would have, but I don't think anyone else did. I never asked the question again.
You know, when Congress enacted the civil rights legislation, a couple of the titles did not provide for jury trial.
Yes.
Such as the housing title. And the legislative record is clear. The fear in Congress was Southern jury nullification. And that led to the case of Curtis and Lowther in the Supreme Court, which ironically came from the great southern state of Wisconsin, involving a white landlord and a black family. And the Supreme Court said that the Constitution trumped and that there would be a constitutional right to jury trial if the statute was silent. Where have we gone?
Well, I'd like to respond to that, too. I also tried a case in which I asked the jury panel, how many of you are opposed to interracial marriage? 1 stood up, 2 stood up, 20 stood up, 70 stood up out of 100 in a little town called Dothan, Alabama. That's your housing and your racial aspect. So, this sort of the virtue of juries, I just want to throw that out, that they're not necessarily a virtuous institution, even though I think the argument about that we should have them remains. But I think it should be put in certain contexts.
They're democracy.
Right.
And we can't get away from that. We have to recognize the majoritarian influences of democracy. Now, we say, and we try as hard as we can to counteract those biases with the requirement of unanimity by confining ourselves to the rules of evidence and by instructing jurors as to what their responsibilities are. But when you ask the first question, why are they in desuetude? In part, it is precisely what we're talking about, that in significant areas of the country, it was believed that jurors would not follow the law, and therefore you got away from this majoritarian but local, that's the thing, they're local institution. I haven't got an answer to that. I espouse democracy and recognize its limitations. We do the best we can within the framework. A problem, though, let me add something else, though, another dimension to this. Juries not only do what Judge Pratt says, they expand a citizen's involvement in democracy. These studies show conclusively that people who have served on juries are more likely to vote, for example, after jury service, are more likely to be involved in their government. We talk about judicial independence. They were talking earlier this morning about judicial independence. And all we talk about is the Supreme Court. Now, we have something in this country that no other country on the planet has. We have first instance, I can't think of a better phrase, first instance constitutional adjudication. Now, we do everything else before we can do that, but you're looking at people here who have, and this is constitutional bedrock. It goes back to the case called the William out, I might say, of the District of Massachusetts. You're looking at these individual non-elected folk here have the right and obligation in some circumstances to declare an act of Congress passed by overwhelming majorities and signed by the popularly elected President of the United States unconstitutional. And we all say, oh, okay, we won't enforce that until we can get to the Court of Appeals and maybe ultimately to the Supreme Court of the United States. There isn't a nation on the planet that has that. And you know why we have that? Because as we started out and we were really sort of figuring out what judges in fact did, judges in the first century of our existence, and we still today, had to instruct juries. And if you have to instruct juries as to the law, you have to make it clear what the law is. And in a system with a written constitution, you have to square the Constitution with the enacted statutes. And if they don't square, you have to do something. Most countries have constitutional courts. Germany, Japan, France, Italy, they all have Russia, they all have constitutional courts in the capital cities. Out in the provinces, the trial judges who don't sit with juries are like administrative hearing officers. That's the civil justice system. The incredible judicial independence that makes everyone's constitutional rights as close to vindication as the nearest federal court comes from the fact we have juries. We sit with juries. Now, if we're going to do away with that, if we're going to make that only the occasional thing, and of course that's what we're doing, This is the greatest change in our jurisprudence that we've had in 200 years, is the marginalization, I'm getting off the topic, of criminal and civil juries.
How do you explain then that in the South we did without juries in the civil rights area and it was better? Some people might say it was better, not
Some people would say it was better.
Don't you think, in fact, it was better? How do you square that with your...
I certainly praise the extraordinarily courageous federal judges in the South during that period. How do I square it? Deep-seated racism, unconscious and conscious.
Do you think it was proper?
I recognize it.
Do you think it was proper not to have juries then?
Was it proper? Again, who was it? I guess it was Holmes, knocking Holmes earlier. You know, or was it Brandeis? The law is not logic; it's experience. And given that experience, I would have to say, on balance, it was for the best.
But I think there is a real unstated assumption going on in this dialogue, and maybe it is mostly, although not even there, perhaps entirely, justified in the civil rights area in the South in the 50s and 60s and to some extent the 70s. But the unstated assumption is that judges have this sort of perfect and mechanistic ability to apply the law to the facts, and so they are, in some sense, better than juries. And I take real issue with that, and with all due respect to my fellow panelists, who I think are terrific and work very hard, they do inevitably, because they're human, bring their own biases and perspective and experience to cases. And so, for example, when Judge Young says don't rail against the PSLRA and these Supreme Court-made standards and so forth, well, among other things, it is judges that apply them. And I can tell you as a practitioner, I can get a case and file it in court, and I know whether or not the complaint is going to survive a motion based not upon the strength of the complaint or the strength of the case, but based upon what judge my case is assigned to. I can predict with 90% accuracy that Judge 1 is going to dismiss the case and Judge 2 is going to let it go. And it's the same PSLRA, it's the same Daubert motion, it's the same Dura motion, it's all the same body of law we're dealing with, but different judges apply them differently, just as juries apply things differently. And so the question, it seems to me, is to what extent do we really want a single person, as opposed to 12 people, a single person who has a much narrower base of experience and who is not sort of on a broader societal level giving us sort of the benefits of opening up the process to this democratic ability for citizens to get involved. Do we want cases being decided by judges?
Yeah, but Brad, your point has validity only to the extent that you're talking about motions that have factual issues embedded in them, and then we can debate, well, is the judge a better adjudicator or a jury a better adjudicator, analogous to the Markman concept, or is it a pure issue of law in which the jury trial is not implicated? I think Brian's point almost from the outset was, and obviously anyone who's read my article knows I believe this, that judges, God bless them, are constantly intruding on the fact-finding process.
But that's my point. That's my point. There no doubt about it, there are occasionally pure legal issues that can be decided on motion. I had a case recently where I agreed with defense counsel that we should submit the case to cross motions for summary judgment because there were no disputed issues of material fact, and the judge ought to decide what the law is. And those cases exist and they're out there. But increasingly, standards are being created and hurdles, roadblocks, these Dura motions and these Daubert motions, where the judge, it's not a pure issue of law. It is not a pure issue of law whether or not the expert has sort of sufficient gravitas and the articles have been sufficiently peer-reviewed and sufficiently credible opinion to let that opinion go to the jury. That's not a pure issue of law. There is fact-finding inherent in that.
that is a...
Go ahead, Judge.
Are we talking to me? I'm sorry. And that's a discretionary call by the district court. But some of the problem is, and I respect the Supreme Court and I will carry out their mandates, but some of the problems come with the standards. For example, on a Rule 12 motion now, on what do we have to take as true? Well, you don't take as true if it's just a conclusion. Or if it's a factual dispute, a legal conclusion masquerading as a factual dispute. Those standards are very difficult to get your arms around as a conscientious judge when you're looking at a complaint. Bear in mind, we're just looking at a complaint. And so the standards are just they invite, I think, that type of judicial decision-making because the standards are so indeterminate on what they mean. And so it's easy to blame the judges for making factual determinations, but sometimes it's hard to tell what's a legal issue and what's a factual issue. And the standards for determining the difference between those two things is not entirely collusive.
Professor Miller, there's an assumption that I think that people are making, and that is that you have a judge who makes decisions, and he or she has this education, and then you have the jury, which is reflecting the community. Now, the judges here, I think all of you are federal judges. Is that right? Everybody's a federal judge. In the state courts, often the juries do not represent the community at all because the people who are part of the community for two fundamental reasons don't serve and are not there. In a whole panel like this, people with a lot of education find ways to escape the jury. People who are under economic hardship fear jury service more than they might fear if there were military drafts because they'd have to be working for $6 or $9 or $10 a day and they can't afford that. So the jury that one ends up with in certain parts of our country does not reflect the community as a whole. There are people who will serve because they are retired or they're in situations where they're not working. And we developed something called the Jury Patriotism Act. It's now law in 15 states to address both of these things so that the jury actually is the community. First, get rid of all these exemptions for the priest and the in one jurisdiction an embalmer was excused. I guess maybe it was a small town, that might be all right. But and also see that the people are adequately paid. And in Arizona, where the Jury Patriotism Act is law, a small fee is put on people who can afford to go to trial, and jurors are paid up to $300 a day if they are on a long trial. And then at least you have a tension between a judge and a jury that reflects the community. But I'm suggesting to you that in many states, even now, the jury does not because of those two factors.
Let me push you on that, Victor, because what you say is right. The exemption structure works in favor of certain classes or whatever you want to call them. But what about the lawyers, lawyer behavior on voir dire?
Well, each side is going to try to get rid of the people that they don't want.
Like the smart ones.
No, I'm not sure about that. It depends on the type of case there
I have never been picked for a jury. They throw me off at the slightest provocation.
Are you assuming you're smart?
I have gravitas. I may
there you
be
go.
dumb.
Well, I think anyone who has a lot of experience with the law is generally regarded as a risk by both sides.
Try not wearing a vest.
And but anybody, they want to have people who they're lawyers on both sides are worrying about somebody like yourself taking a leadership position with a jury, and that you're not really getting the jury result, and both sides regard it as risky. One of the things I found is that with voir dire, it often doesn't work because you can't find out from jurors what they really saw on television that influenced them, and they don't even really know about it. So there's a limited value to it. But the basic point is true, and that is that in some jurisdictions, state courts we're talking about, the community is not represented. And people can serve, and they should, and companies that rail about juries and complain about juries. Often, if you really look deep into their policy, may not encourage people who are working for them to serve on juries. And the executive who gives a speech about our jury system and the problems with it may, if he is called, do everything he can, or she, to escape jury service. So we're trying to do things to see that people actually do serve regardless of wealth, and that's the big one. As I say, it cuts two ways. The fellow who works at Subway doesn't want to serve because he can't afford it, and the one who is an executive doesn't want to serve because he feels he or she is essential to his job.
Judge Pratt?
One of the things that Mr. Schwartz talked about, I think, is reflected in this movement about the concern about the decline of jury trials was really started by Judge Young. He wrote an article in the Federal Lawyer, July of 2003, an open letter to U.S. district judges. That, in turn, I think, was a substantial cause of Robert Gray, the then president of the American Bar Association, starting a jury commission. I've attended a couple of their meetings. And President Gray did a wonderful job. This has driven a number of reforms that Judge Young just briefly mentioned, juror questions. There's an article, if you're interested in jury service and what some of these reforms have done and about why we judges need to rethink the problems of jurors in the 21st century. Patricia Refro, who's on the jury commission that President Gray appointed, wrote an article in the Stetson Law Review, which I use frequently. It's called The Ethical Treatment of Jurors, and you may want to refer to that. The other thing that we're into with technology, and this is, to my way of thinking, a problem we have to think about how we're going to handle jury trials. There's an article in Litigation Magazine about digital trials in the year 2020 and the way we treat jurors, snipping testimony, using DVDs, only having juries show up for the opening and the closing. There are a lot of issues out here about the way we do jury trials that Mr. Schwartz commented on.
Judge, in the same general vein, there is increasing evidence that jurors, being human beings, when they leave their service at the end of the day, do not obey the command of not to discuss the case with others, and they sit at home either talking with family or on the internet doing their own research. And these days you can get a visual view of an accident scene or articles on a particular technology that may be an issue. Have we now reached the point where the traditional platitudes of close your mind, close your eyes, close your ears and nose and throat, it's a fiction? The jury will disregard that last 800-pound gorilla that came into the courtroom. Are we living in a fantasy world, or is there any way of adjusting for that?
I don't think this is a new issue. If you've ever circuit rode as a trial judge and you have a car accident in your case, 90% of the jurors are going to drive right by the scene where that accident happened. And you will tell them, you cannot drive that way. You've got to drive 90 miles around it. I don't know whether they're going to comply with that, and my guess is that a lot of them don't. It's just part of the system. I actually think perhaps much is being made about this, but I don't really think it is a new issue. We have more access to the internet, obviously, and jurors use the internet now. We all use it. But it comes down to just a matter of faith, and I think the judges obviously going to have to change their charge. But I think the issue of jurors taking it upon themselves to go out and seek information has been with us since jurors were walking from the backcountry roads to the trial court and had to walk by virtually everything that was involved in the case. It's just a different way of seeing it.
The dimension may have shifted.
Right.
But I think it's unnatural to expect jurors not to talk about the case among themselves when, as one article pointed out, the only thing they have in common is the fact that they got jury duty. So to ask them not to talk about the one thing that they have in common is really kind of unnatural. So I wouldn't have a problem with jurors doing deliberations as long as they're together. And I think one study found that even when you tell them not to do it, 42% of them did it anyway. So, and what is really so damaging about letting people talk about the issue at hand, as long as they're all together. I just don't see a big problem with that.
What do judges do in that regard? I mean,
My standard
what
charge.
prescriptions do judges place
Yeah,
on themselves?
I don't, that's the one supposed reform that I don't buy, and the reason I don't is that trials are linear. Plaintiff gets to go first, and if they start talking about it before they've heard all the evidence, the very discussion has them lining up. You can't, I feel so strongly about that, I don't talk about the substance of a case with my own staff, because you're going to take a position on it. And as Judge Thompson said, and Judge Vance too, part of these things are matters of faith, and yes, we should change our charge. I am satisfied with a charge that explains why they shouldn't talk about it, and here's my charge. I mean, as soon as they're impaneled, among other things, I give them this charge. Now you can leave here and you'll go back home and you can go to work and we'll start tomorrow. And you have every right to tell people, yes, I went. Yes, they kept me. He tells me it's going to go a week. He promises us that. I can't be sure of that. Of course, you have to arrange your schedule. But don't talk about the substance of this case. Because if you do, just as sure as tonight will follow today, whoever you're talking to is going to tell you what they think about it. We're not interested in what they think about it. You're the ones who are chosen to be the judges, and I am very big on always calling them the judges of the facts. And then I tell them, when it's over, you can say anything to anyone about anything having to do with this case. But while it's going on, I don't close your mind the way I say it is. Keep your mind suspended. And so I have just that thing. And I now expressly say, don't go on the internet.
I think you're talking about something different, though. I think she's talking about the jurors talking among themselves.
Oh, she is.
Yeah.
And for that, I think that your charge is great. But I think it's more of an aspirational charge. We don't want them engaging in a free-for-all discussion, but we know that they're probably going to engage in some discussion. I mean, that's just human nature. So I think the charge should be there. That's different from talking to someone on the street.
Yeah, I agree with that.
So it's a shocking fact of life that the jury trial is a human institution.
Well, Arizona will allow it, of course. That's a reform in Arizona, and it's being studied. Arizona's charges will allow them to discuss the case while it's going on with a caution they shouldn't make up their minds.
I think some of the research has said that it has not produced a bias in favor of one party or the other to permit them to deliberate as they go along. But at the same time, they said it has produced shortened deliberations. So
There's a prof at Northwestern. We had her talk to our conference last year. There's the Arizona Jury Project that Judge Vance is referring to. They actually studied 50 civil juries, and I think the quote that Sarah had, the Sherry Seidman Diamond is a wonderful prof, along with being an ABA fellow. She's in charge of this, and she said, I think Sarah's quote was, the instruction that they were given, the jurors in the Arizona Jury Project, was not to discuss the case among themselves. Some incredible statistics, 71% of them ignored the admonition in any event.
We want to pare down the rules that are sort of silly and keep the rules that are really needed. Maybe a rule that is really needed is not to go on the internet, but a rule that says they can't take notes, other rules that seem arbitrary to them may result in them not following any rules. If you focus on a couple that are really important, they may find them. I worked with President Gray that year, and that was one of the things he was interested in. And we found this film, I don't know who made it, some of you may have seen it, where they showed a classroom where the teacher or professor had to follow the rules that are done with juries. And no education really could proceed if you put them all together. I mean, they couldn't make notes, for example. So honing down the rules to what is really important might produce jurors being more respectful of the rules.
Professor Miller, I'd like to just mention this. I think watching lawyers try cases is the best part of my job. That's the most educational for me, I mean, I learn a lot from other lawyers and judges and law clerks. But when I see a jury deliberate on it, and every case is important, that's the single best part of my job. So this idea that judges don't want to try cases, for the most part, I think is a myth. We'd love to try cases, and all these inhibitions that have just been discussed here today get in our way, frankly.
Well, we started a cult of judicial management in 1983. And I am an unindicted co-conspirator because I was the reporter to the Civil Committee that took Rule 16. Some of you may recall that Rule 16 was an eve of trial, single conference structuring of the trial. And Rule 16 is now judicial management from Genesis.
You know, these things all have nuance. It's not wrong to have judicial management. Any judge worth their salt is going to manage because we owe a trial, we owe a dispute resolution. And I happen to be very much in favor of ADR, voluntary ADR. So there's various ways to get to a just result. Trial is only one, and I claim that as our specialty. So management is fine, but it's got to be management not in an end to itself, because you tend then to get into the situation of getting rid of the case. My point is simply this: it's management to get to trial, which affords the parties the opportunity to settle out at any stage. Because, of course, most cases should properly settle.
There's one thing that we haven't mentioned. Indeed, the word has not come up in this session, and that's arbitration and arbitration clauses, which are now ubiquitous. Now, does that pose a threat to the viability of the jury trial availability in the future as whole industries move to arbitration clauses?
Well, it's certainly
Yes.
one more big hurdle, and it especially comes up in the types of cases that Judge Thompson was talking about, where you're talking about the little guy, especially because more and more folks are parties, unknowingly usually, to arbitration provisions in form contracts. Oftentimes they don't even sign because it's just a function of getting your telephone service or getting your credit card. And embedded in there somewhere is a promise to arbitrate any dispute that you have. And in the old days they would call that a contract of adhesion, and it wouldn't be enforceable. Yeah. Now they're looked at sometimes very differently, and it becomes another hurdle.
Also, you tend to be unable to get institutional resolution if the dispute concerns a very small amount of money.
There's no, I mean, effectively, there is, for many of these cases that are being referred to here, there is effectively no resolution if there isn't a judicial resolution, often an opportunity for a class action. And, I hate to say this, but the Federal Arbitration Act has been given such broad reading by the Supreme Court that there's a lot of litigation about it, but it is at the margins. I mean, there's going to have to be congressional attention to the question of arbitration and class action bans in arbitration clause if there's going to be something significant done about it, and there is pending legislation, and it may move.
The irony about arbitration now is that arbitrators are now permitting discovery, and they don't exercise any control over the length of, especially in big commercial arbitrations, they don't exercise any control over the length of the proceeding. So what you have is federal court without the judge and without the public verdict and the potentially public resolution. But it's mirroring the litigation process now with broad discovery and sometimes motion practice in arbitration.
Although I would really distinguish
Yeah.
between two kinds of arbitration. I mean, you have arbitrations between two big multinational corporations, and I think that's what you're really referring to.
It is.
And that's true. But you also have ordinary folks who are subjected to arbitration provisions that more often than not end up hauling them before a panel of arbitrators who are really beholden in many respects to the industry that they're arbitrating against. And so they're going up against a stacked jury, because if they ever, and it's not a jury, because if they ever want to be back on another panel, they know who they better be ruling for.
All right, we have talked about the glories of the jury trial system, and we've also acknowledged some warts and bumps in the jury trial system. And it's a stacked panel because at one level or another, you're all jury trial lovers. What do each of you see for the future, either constructively or destructively? Will there be a brighter day ahead for the civil jury, or will we go the way of our forebears in Great Britain and bag the thing for all time? Judge Pratt?
I think it's too early to tell.
In other words, it's still a ball game.
Yeah, I think all the concerns that Judge Young voiced in his article are still true. I'd throw in, the cost. I mean, the lawyers on both sides always tell me, well, we can't afford to try the lawsuit. So I don't know, the cost, why we have, 98% of the people in the United States can't afford to go to a law firm. So I think cost is a huge part about the jury system in the civil sense remaining a viable institution.
Judge Young? I know where your heart is.
Well, I'll speak from my heart. We have to save it, and we have to make it flourish, because the justice system without it in America will not be the same at all if it continues to be marginalized. Justice Souter gave two magnificent speeches, and in both of them he cited something that the great Judge Richard Arnold said, and it really struck me. I knew Judge Arnold, and I'd never heard this, but it just seems to capture it. And on this one, we have to make the jury system work. Judge Arnold said, there has to be a safe place, and it has to be us. And now in a criminal case, we have a tradition of having the jury stand up, and the judge stands up. And he just, at the beginning of the charge, and he just tries to call the jury to their duty to apply the law fairly. And I've altered mine because I think that quote is so magnificent, and that's how I start out. And I look at the jurors and I say, it has to be us. These words have to mean something. Justice, equality, fairness, here, now. And we simply have to save it, and we will.
Judge Thompson?
I actually see the issue as a little bit broader than just saving the jury trial. I think we need to save public trials. Whether they are jury trials, to me, is a separate matter. But the public trial, to me, is essential to holding institutions accountable, holding entities of power accountable, and allowing people who are small, who lack power, to be heard. And whether it's before a jury or a judge, I think that's what's critical, is that ultimate requirement. Obviously, we have the amendment, the constitutional amendment that requires jury trials. I think that helps. And I think jury trials are good too. But as I've made clear before, I think we all have to look at them and be careful about them.
My wife's not here to contradict me, so I'm going to claim to be an optimist, and which I am. And I really believe in pendulums, and I think that we really have reached the end of the swing. And I do think that there is going to start to be a swing backwards. I think the judicial system of the three branches of government probably lags the most, but I think we've seen sort of a sea change in the last two elections on the political front, and I think that ultimately is going to have an impact on some of these standards and on the people who are applying the standards, and I think we will see more civil jury trials. At least I hope we will.
Judge?
I think the civil jury trial is here to stay. I don't think it's going to become a complete anachronism. I do have concerns about whether or not we're pricing huge numbers of people out of federal court, at least in terms of your ability to afford to try a case in federal court. But I think as long as the jury trial rights in the Constitution, there are going to be people who want to make sure that it's preserved and protected. So I don't see it becoming a complete anachronism.
Do you have any sense of what will turn things around?
I think that to really turn things around in terms of making jury trials a whole lot more available, we have to cut the costs of federal court litigation and speed up the time to trial. I think it's what Judge Young was saying, just making it available, to make it our job to make it available and to get the decisions made quickly enough to try to control the discovery, because nobody likes controlling the discovery. The lawyers like discovery, so we're going against the tide trying to cut those costs. They're not easily cut. It's like medical spending. And but that, I think, has to be done, and that's really difficult for trial judges to do, to try to close that window, get the case ready for trial, and try to reduce the opportunities to spend money.
Victor?
You have a constitutional perimeter, so in criminal cases there's going to be juries always. In the civil cases, there are also state constitutions, and I don't see voters voting to repeal those provisions. But here's, over time, I think, where there'll be a change. Jurors do their best when they come to a panel where they can use their own life experience to make decisions. In some areas, they're so complicated that the jurors don't understand those areas very well, and they're left to decide between a battle of experts, each of whom is highly educated, and the juror doesn't, by definition, have the experience to decide. So I think in those cases that are very complex, there'll be alternative means to make a decision. And one way or the other, that trend is going to continue, so that the jurors will last where their knowledge is best, and alternative forums will be selected for areas where jurors simply don't have the background and experience to make a decision.
Brian?
I want to, as I think Judge Thompson did, fight the hypothetical a little bit, fight the question a little bit. I want to make it a little broader, which is, I think, and really a challenge to the audience here. I think our job is to fight the hostility to litigation in the civil justice system that has been foisted on the society for the last couple decades. And I think that's really our obligation. So when we hear things about juries being out of control, punitive damages out of control, we have to respond with the facts. The facts, not every fact is pretty, but most of them are. And we have to respond with the facts. And particularly in terms of the litigants that Judge Thompson is referring to, the little guys who are up against large, powerful entities, we have to explain that what's the alternative? The alternative is accepting the status quo. Instead of being able to get a dispute resolved in front of a judge, the litigant has to accept the existing social and economic relations, even if the substantive law says otherwise. And we must fight that and just explain why that's unacceptable.
7 views, 7 talented panelists. I thank them for their participation today and you for being here. And as I said at the outset, please feel free to go up and talk to them. View them as a community resource, at least for 15 minutes.